Good morning. This is MacIntosh from Rabideau Law. I'm going to be doing a presentation today on access during COVID-19. What we'll be focusing on is just how the courts are sort of reacting to this, what the courts are sort of expecting from parents regarding access between them and for the children. And we'll be going through that and showing a case that highlights that and how some implications that can affect that as well. What I'm going to do here is I'm going to share my screen. I'm hoping that shows up no problem. And so I'm going to go through that. We're also recording this, so that will be shared online and can be emailed out as necessary. So I'm really hoping that this is showing up on your screen so that you can see what I'm looking at. It's this presentation here regarding access during COVID-19 that I will be going through. So just starting off with an introduction here about the current implications. So one of the major concerns, of course, we have from clients is, what are we going to do? My other spouse is telling me I can't see the kids because of COVID, and they're using that as a reason to withdraw access or remove access from me. One of the issues being, is the other party complying with social distance protocols from the government? Now, at this point of this recording, the government has recently gone into stage 3 of reopening businesses. So there's more social gatherings that are allowed. It's been opened up a little bit, but still a lot of these issues are still front of mind for a lot of parents and for courts as well. As this progresses, we're also getting a lot of notices to the profession, from the courthouses, regarding how is procedure working, how can you file materials, what is a court willing to do at this time. So one of the main cases I want to talk about today is RIBEIRO v. RIGHT, RIBEIRO and RIGHT. So it's a decision regarding what parents can do regarding access during COVID, and it's pretty important here to identify that this is a case where the court has identified that it is very important that kids and children continue to see their parents in accordance with the existing agreements or the status quo. Basically keep the same scheduling for access as you have before, unless there's some emergency or something else that would affect that. Whatever you've been doing before should continue. That's the idea. So here was a case where a mother tried to bring an urgent motion to suspend father's access, saying he wasn't complying with social distancing. So, you're not spending the proper 2 meters apart, and I know this, so you need to make sure that you don't have access anymore. Here's Justice Alex Pazarat stated here: a blanket policy that children should never leave their primary residence, even to visit their other parent, is inconsistent with a comprehensive analysis of the best interests of the child. And this is always very important. The most important thing, one of the most important things regarding access. What is the best interest of the child? In this interest, Justice Pazarat is clear in saying, making sure the children see their parents, that is in their best interest. But having say that, they just can't leave their primary residence whatsoever, and even to visit the other parent, that's not going to fly here. So continuing on, Justice Pazarat denied that mother's motion. Remember, she was trying to say, I need an order from you, Mr. Justice Pazarat, saying that my other spouse can't see the children due to COVID. He says, no, I'm going to deny that motion for you because it's in the best interest of the child to see both parents as much as possible. And here we see that there. The existing parenting schedule should remain in place, barring any legitimate safety concerns. So if there's like abuse or there's health concerns in the home, you might be able to use that to try and adjust an access during COVID, but not simply because of COVID, the other parent can't see the child. So what courts also are clear to state is that this should be negotiated ahead of time. No parent should just unilaterally make a decision regarding withdrawing access. It's in bad taste, basically. Regarding court operations. So if it comes out that one parent is not letting the other parent see the child, what can that parent do? Now, courts have limited function during COVID. It is opening up. They are allowing for regular applications now. Before today's date, well, most of it was just emergency orders is really what they were going to hear. But now they've opened it up to more case conferences, regular application proceedings, and the like. Just be mindful that courthouses are still closed down, minimizing as much in-person contact as possible. So a lot of appearances at this point are also virtual. So Zoom is one application that courts have asked persons to use so that you can still meet with a judge and even gives you ability to show documents when you're in an appearance. So anything from March to April of 22, those are appeared to first appearances or to be spoken to. These are basically like scheduling dates. Now, this has opened up again as well. So we're seeing right now that as of July, what date is it today? 22nd, that if you start an application now, you're most likely going to start getting appearances September, October, or November. So that's what's going on at this point. Okay. Also, what's important, we are getting a lot of notices regarding what you can file and how much. So there's very strict rules about, what you're emailing to the courthouse, who you have to email to, what you have to put in the body of the email, the size of the files, which is also very important as well. If you need to file materials at the courthouse itself, courthouses have limited operations. I know in Kitchener, the hours, last I checked, was 10 to 2 and 2 to 4 as of July 22nd here. So that, again, that might be opening up soon, but you have to just be mindful of those things. Another important fact here is that there's a suspension of limitation periods. Usually, if an application or something is initiated, there's a certain time frame where a party can respond. That has now been suspended indefinitely until further order from the government. We can see that here in this emergency order that's been provided. So any provision of any statute, regulation, rule, bylaw, or order of the government of Ontario shall be suspended for a duration. And that only goes back to March 16th, 2020. So you have this window of time here where you don't need to abide by limitation periods, provided you follow these guidelines here in the emergency order from the government. So, as I was mentioning before, the urgent motions are still one of the most important matters that courts are still very keen on making sure is still progressing pretty strictly. So again, there's strict rules on how this can move forward. You may not be getting an in-person hearing, but it will most likely be virtual. I had an urgent motion that I had to do myself. It was done over the phone. It was done virtually just because of COVID here. So it's important to know that with an urgent motion, there's a specific guideline, like a bar you need to meet in order to justify being able to hear an urgent motion. And also be mindful that the court has the ability to determine if they're going to hear this urgent motion. They have the ability to triage it to determine how urgent is this really. Moving ahead. So if a person has been denied access, they may be able to rely on this urgent motion. So denial of access really is no access of any kind. That means no phone access, no Facebook access, nothing like this at all. That creates a higher level of urgency. If the other parent says, oh, I can let you can see the kids an hour on Saturday, that doesn't count as urgent anymore. It's not acceptable depending on your circumstances, but it doesn't meet this threshold for urgency, allowing you to get that immediate sort of motion response. Now, because of COVID, where lawyers are doing a lot of negotiating with opposing parties regarding access exchanges, that can be accommodated for. Courts always want to see people negotiating outside of court as much as possible. So as I was stating before, parties should be sticking to the existing agreements. If there's a court order or a separation agreement in place, you should be following the language of those orders and agreements, barring any safety concerns or anything of the like. So if a party is blatantly failing to follow through, depending on the extent of it, you may be able to do that urgent motion. If not, you'll have to consider a regular application, which is not a much slower process, but it is a longer process to get any sort of result. Now, one other issue that came up with some of our clients is how criminal matters now can intersect with these family matters regarding access. So if there's an order regarding access, and if there's a restraining order in place, this can create more complications now. Because if it turns out one party says, oh, no, he breached the restraining order, all of a sudden there's this criminal matter you got to deal with on top of this family matter during COVID with this minimal access to the courthouses. It just really starts to conflate the issue here. So we had an issue where we had parties who were to communicate through email. However, there was also unsupervised access that the father was trying to arrange with the mother. This was still ongoing litigation at this time, because there was also an existing older order, which had actually been sort of changed now because of a newer order. And in this older order, it said that there was supposed to be no communication, basically. So there was an issue here because the father tried to contact the mother in accordance with the new order language, saying he could email her, but then she then called the police, relying on an older order, and said, no, he's not allowed to contact me, I need a restraining order. And because the police were looking at the older order, they put the restraining order through, client was charged, and there was months of having to try and resolve that criminal issue before he could see the kids again, because in the restraining order, she put that, can't be in contact with me or the children. So that really complicated the issue and made things a lot more difficult for him. It was an error, but even this error caused him all this grief and suffering over a few months to clean it up. So yes, he was arrested. He was released on an undertaking, basically, and then he had to hire a criminal lawyer as well too to help him resolve this issue, and having to pay those fees and whatnot. Luckily, there's a possibility he can get those recouped, bringing now a civil claim against the other party. But now, just because of this misunderstanding, it's really created a huge issue. And because of COVID, the fact that we're not able to get into court as easily, it is opening up. But at the time this happened, it was not as easy to get a lot of these materials in. Eventually, the matter was withdrawn. As soon as the orders were in place and presented to the prosecutors, they were understood that, okay, this actually didn't need to happen, so let's just have this withdrawn. But the damage had already been done, right? So that's the important thing about this, is that criminal and family court do not communicate with one another. It's the job of the clients essentially to notify the lawyers on each side, to notify the criminal court, hey, I have this family court order that actually gives me this right, and then so that they're notified about what's going on. As I was mentioning, COVID exacerbates that gap. So this is why it's important. Make sure that you always have the most up-to-date versions of your documents with you, in case there's any issues that could arise. So you can always produce the most recent order and say, hey, this is actually what's going on in our situation here. So sort of starting to wrap up a bit here. Most court appearances right now are virtual. There is the odd time you may be able to get in person with a judge, but they want to minimize that as much as possible to avoid the spread. So even if you are appearing in person, of course, you still need to be mindful of health measures. The court will give you instructions on how they expect you to compose yourself and behave when you're in court, what sort of PPE they may require you to wear. So it's always a good idea just to make sure you're up to date on the instructions from the court should you need to appear. And that sort of wraps up my presentation there. If you have any questions regarding what I've discussed here today, feel free to call us at Rabideau Law there at 519-957-1001, or you can get us at our email, rabideaulaw.ca. Thank you very much for your paying attention and listening to our presentation. We really appreciate it. If you have any other issues or concerns, feel free to give us a call. Thank you.